For judgment, item number 1.
The writ petition is found to be devoid of merit and stands dismissed accordingly. All right, I'll have division bench now.
Dismiss.
Oh. Yes,
We plead it options.
yes.
My lords, I beg to mention item number 41. Item number 41.
41.
Yes, my lords. My lords, in this case, the pleadings are complete.
Hmm.
Let this case be listed in the usual course for hearing.
But the learned counsels of both sides. The pleadings are complete. List for hearing in due course.
My lords, much obliged. My lords, I also beg to mention item number 55. This is in the hearing, my lords.
Hmm.
But I have told my learned friends that there is another hearing matter which is fixed
Hmm.
for hearing today, and it's likely to take the whole day.
Okay.
Yes, my lord. So in that case, I pray that this case will be fixed on the 8th of May.
Okay. After hearing the learned counsels of both sides, the hearing is adjourned today, list on 8th of May.
Much obliged.
Please, your lordships, I beg to mention items 7 to 40, lordships. Uh, As per dated 13 September 2023, 23, lordship, comprehensive affidavit, additional affidavit has been filed by the state. So allow me 2 weeks' time to go through to peruse the affidavit, also to seek instruction, lordships.
You are for the petition.
Yes, lordships, petitioners.
Learned Counsel MS,
Nitya Okoza, lordships.
appearing for the petitioner, submits that the state respondents have filed the affidavit,
Additional affidavit.
comprehensive additional affidavit. And therefore, she needs some time to go through it. Accordingly, the Learned Counsel prays for some time. I have also heard the Learned Counsel, Mr.
And Mosoi.
Appearing for the state
Very good.
respondents,
Very good department.
Health Department. You are for one, respondent number 1.
I put 2, 3, 4, 5.
Learned Counsel so-and-so appearing for the respondents 1. The prayer of MS so-and-so is allowed. When do you want it?
After 2 weeks, lordship.
Least after 2 weeks.
Obliged.
Obliged.
May it please lordship.
Yes.
My lord, I beg to mention here in item 65 to 67 that this matter will be listed after 2 weeks, lordship.
65 to
67. lordship.
on the request of the Learned Counsel, Mr.
W. Marfu, lordship.
W.
W. Marfu.
Marfu.
Lordship.
The W. Maru, M-A-R-H-U. Appearing for the petitioner. The matter is adjourned today. Least after
2 weeks,
2
lordship.
weeks.
May I please your lordship?
Yes.
Your lordship, on behalf of Z Khalid, I beg to mention item number 49. Let the matter be come up after 2 weeks, lordship.
49.
Yes, lordship.
On the request of the Learned Counsel, Mr.
Z Tushidamjan.
Appearing for the petitioner. The matter is adjourned today. Least after 2 weeks.
Much obliged.
Yes.
May I place your worship? My lord, your worship, I pick to mention item number 42, 47, and 48.
48.
Yes, my lord.
What are the numbers? 47 also.
42, 47, and 48, my lord.
Just a minute.
Mm.
42,
Yes, my lord. 47 and 48. 48.
47, and 48.
Yes, my lord.
On the request of the Learned Counsel, Mr.
Z only, my lord. CGC.
CGC. The matter is adjourned today. After 2 weeks.
After 3 weeks, my lord.
After 3 weeks.
Obliged, my lord.
Yes.
May I please your lordships? I beg to mention item number 56 to 64.
56 to 64.
Yes, your lordship. I plead this matter may be listed after 3 weeks.
Sure.
56 to 64.
On the request of the, you are the government advocate.
No, your lordship. I'm for the respondent.
You are for the respondent. On the request of the Learned Counsel, Mr.
Benison V. Shoy.
Appearing for the respondent. The matter is adjourned today. I have also heard the Learned Counsel, Mr.
E.T. Papon for the statement.
For the state. The matter is adjourned today, least after 3 weeks. 3 weeks.
Much
Obliged.
obliged.
For motion, item numbers 1 and 2.
Yes.
Yeah, please, your lordship.
Lordship, the IA is an intervenor application praying for implement as respondent number 8 in the PIL number 2 of 2024, Lordship. Lordship, the applicant is a public spirited citizen. He's an advocate that of profession and a native of Chichilimi village. And the three village councils, his village and two other village, Pukie and Lokai, had a consultative meeting on 13/4/2024. And through a resolution had authorized the applicant to represent their interest before this honorable court. So he has filed this application in his personal as well as representative capacity, Lordship. Lordship, the matter relates to road construction.
Road construction.
Yes, Lordship, the government of India had approved for the construction of a road from Lordship Shoba to Pangsha. Malar Shoba is situated under Dimapur area, and Pangsha is Lordship under Noklak district. That is the international trade center between in the Indo-Myanmar border. East-West corridor. Malot, this is part of Act S policy. Now the issue relates to Malot. The construction is divided into 6 sections. Now the matter relates to construction of section 3, which starts from Mukhalini to Zanipoto. Now, Malot, initially 2 options, route alignment, 2 options were proposed by the government and the technical committee. The government of India, in terms of the guideline, has approved the option number 2. That is part of which fall within the jurisdiction of the applicants. Now, my lord, that is challenged by the villages which falls within option number 1. That is the facts of the case, lordship. I'm not going into the merit of the case because it is only for implementment.
Yes.
So, my lord, the issue is a tussle for good routes between the 2 area. My lord, the only test led on to the Honorable Supreme Court for implementment is that one should have sufficient interest in the outcome of the case.
Yes.
No, my lord. So we are approaching this Honorable Court for implementment to give us an opportunity, because, lordship, if the PIL is allowed, then the proposed construction will be shifted from option 1, which option 2, which falls within our villages, to option 1, and will be deprived of our right to connectivity, lordship.
Yes.
So my humble prayers for to implement us and give us an opportunity. In fact, the area people has been approaching the state government to representations and over the years for construction of the road.
Yes, who is for the state?
Lordship, I am the petitioner. I have no objection, Your Lordship.
Well, the states are pro forma respondents. Yes.
States are performers.
Yes, because they are respondents in the main PIL, lordship.
You are for?
And I am for the applicant, lordship, for the intervener for implementation.
Yes. You are T. Masa,
Yes, lordship.
but the learned senior counsel, Mr. T. Masa, assisted by
Mr. Arun Long.
preparing for the applicant. Mr. I forgot your name.
Lordship, I am TB Jamil for the petitioner.
Preparing for the
For
petitioner,
Respondents, PIL petitioners.
respondents, stroke PIL petitioners. This application has been filed by the petitioner, praying for including him as the respondent number 8 in the PIL number 02 of 2024. Mr. Jamir has submitted that he has no objection if the petitioner is included as respondent number 2.
Respondent number 8.
Respondent number 8. But I have considered the submissions we have considered the submissions made by the learned counsels of both sides. Considering the nature of the case, the petitioner the prayer of the petitioner is allowed. The petitioner shall be included in the PIL number 02 of 2024 as respondent number 8.
Lordship, the registry may kindly be directed to implement.
The registry is directed to make the necessary corrections in the title page of the proceed PIL.
Your Worship, that order may be passed in the main.
My lord, yes, necessary order has to be passed in the main petition also,
Okay,
in view of.
Okay, the IS stance is posted. In the main PIL, you write. At the learned counsel, Mr. T.B. Jamil, preparing for the petitioner. At Mr. T. Masa, the learned senior counsel, assisted by so and so. In view of the order passed in the connected I number 52 of 2024, the office shall do the necessary corrections by including respondent number 8 in the title page of the PI main application for main application.
Lordship, may kindly grant me 3 weeks' time to file after that.
I'll be serving the copy in the course of the day.
A copy. What copy? Oh, so you have not received the copy.
My lord, I'll be serving in the course of the day.
Okay, Mr. Jamil has submitted that he will serve the copy of the PIL to the learned senior counsel during the course of the day.
Lordship, may kindly grant me 3 weeks to file after that.
Released again after 3 weeks.
Right.
For motion, item numbers 3 and 4.
Wait, please, Lordship.
Yes.
The item number 56 of 2024.
Hmm.
This is an application praying for condemnation of 179 days of delay, Lordship, in filing the accompanying appeal, Lordship.
Notice will go now.
Lordship,
Who is for the respondents?
the state as well as some private respondents are also there, Lordship.
But the learned counsel, Mr. M. Jamil,
Lordship,
preparing for the applicant, issue notice to the respondents. The applicant shall take steps for service of notice upon the respondents by registered post agent. Least after 4 weeks.
For admission, item number 5.
Wait, please.
Yes.
Actually, in the cause list, my name is not reflected as the amicus curiae,
Yes.
item number 5.
Yes.
By the last order, I was asked to explain the price disclosed about the affidavits filed in the last occasion. One affidavit, the order is dated 10/4/24.
Yeah.
10/4/24. May I read now? Lucino, learned counsel present on behalf of Mr. A. Zamini, amicus curiae. Mr. Kim Shaw, learned additional agent, Nagaland present for the state respondent, numbers 3, 4, 5, 6, 11, and 12. Sophia, learned counsel present for the respondent number 10. Mr. Joshua Shetty, learned counsel present for the respondent number 9. And Noah Jamil, learned counsel present for the respondent number 1, 2, and 8. On the basis of the order dated 13/3/24, passed by this court, the government respondent numbers 3, 4, 5, 6, and 11, and 12 have filed an affidavit. Shall on the next day, votes should have been filed by the state respondent. So the affidavit is filed on 10/4/24. May I take your lordships to the relevant portions of the affidavit? 10/4/24 at page 2.
Yes.
That the honorable court by the order dated 13/3/24 is directed to state respondent to please report as regards to the result of the meeting that have been taking place between the state administration and the authorities of NHIDCL in connection with the chief secretary of the government of Nagaland, PC number such and such, dated 6/8/2020.
You were reading which order?
Your Worship, I'm reading the affidavit.
Oh, you were reading the affidavit.
Yes, ma'am. The affidavit of the respondents. State respondents, which was filed on 10/4/2024.
Yes.
10/4/2024. Paragraph 2, ma'am.
Paragraph 2.
Yes, ma'am. Paragraph 2.
Yes.
So this is the affidavit referred to in the order date 10/4/2024. In the honorable court by order dated 13/3/24 has directed the state respondents to place on record as regards to the result of the meeting that had taken place between the state administration and the authorities of NHIDCL in connection to the chief secretary of the government of Nagaland, number such and such, dated 6/8/2020. Directions contained in the order dated 13/3/24, passed by the Honorable Court inter area reads as follows. In course of deliberations, it appears that the work in question was for upgradation of NH 39 brackets NH number 2. It appears from GO dated 6/8/20 that the chief secretary to the government of Nagaland has requested the managing director of the NHIDCL to consider compensation and due of land for Kohima bypass portion. This court is also made to understand that meetings have taken place through the state administration and the authorities of NHIDCL, and some decisions have been taken in this regard. It's an interim song letter edition, which has been prepared for the response 3, 4, 5, 6, 11, and 12. Submits that by filing an affidavit, the result of the meeting shall be brought on record. Accordingly, the matter stands adjourned. Now, my lords, if I may pause here for a moment.
Yes.
This letter dated 6/8/2020 is a letter written by the chief secretary to the NHIDCL, saying that for the construction of road projects, apart from damage compensation, no land compensation will be paid. But that decision was subsequently reviewed by the state. So accordingly, the additional AG was directed to place an affidavit on that point on record. And I believe my other friends has some instructions on that point today. So if you can answer.
Yes.
Lordship, here, in addition to affidavit dated 10/4/2024, in connection with the annexure C of my affidavit, here the ministry has communicated to the state respondent for the spot of the road. So subsequently, we have taken the assembly correspondence with the ministry. So I will be allowed to file an additional affidavit to authorize the court. So status of the correspondence taken between the estate and the ministry.
Some time can be given.
Heard the learned amicus curiae, Mr.
Is moving.
A. Jimuni. Mr. Jimuni has addressed to this court pursuant to an order passed on 10/04/2024. The learned counsel, Mr. Preparing for the state respondents, prayed for some time to file an additional affidavit. In addition to the affidavit that was filed on 10/4/2024. The prayer is allowed. When you will file? After 2 weeks? After 2 weeks.
Your Lordship, Lordship, I will be accounted 3 weeks.
3 weeks. Make it 3 weeks.
Lordship, I am appearing for respondent number 10. If my name,
So
if my presence may kindly be reflected.
his name also had Mr. Also had Mr. Give his name as respondent number 10.
Lordship, by order dated 10/4/2024, the contractor respondent number 9 has to file an affidavit. So regarding the work progress report, latest work progress report, which we have filed this morning.
You have filed.
Yes, Lordship.
MS, give our name, so and so. They submitted that the contractor,
Yes, Lordship. Respondent number 9.
respondent number 9 has filed the necessary affidavit, which is available in the record. 1, 2,
1, 2, and 3.
also had Mr. So and so. Respondent 1, 2.
For admission, item number 6.
My lords, this is the second PIL on the same subject. National Highway 329A, within the state of Nagaland, there is already a direction that that highway should be constructed within a period of 3 years. Nothing has been done so far. That is the PIL.
Okay. Who is for the respondents?
Also, in this case, I'm representing respondent number 6 and 7, Lordship, the NHIDCL, Lordship. I filed an affidavit this morning, Lordship.
You have filed.
Yes, Lordship. I filed this morning, Lordship.
Who is for, you are for? Mr. Jimoni, you are for?
I'm for the PL petitioner, man.
You are for?
He's for the state.
Oh, he is he is for state. Then you are for respondent number?
I'm for respondent number 2, 3, 4, and 5.
Who is for one? For one? Union of India?
CGC is here.
CAC is here. Okay, all right. Heard Mr. K. Jimoni appearing for the petitioner. Who filed the affidavit today?
6 and 7, Lordship,
The
NHIDCL, Lordship.
respondents 6 and 7
Lordship.
have filed the affidavit this morning. I have also heard the learned counsel appearing for the respondents. You are for 2, 3, 4.
2, 3, 4, and 5.
2, 3, 4, and 5. Mr. Jimoni, what do you want now? He has filed the affidavit.
On 6 and 7.
Yes.
I have just received my, let's say I finally reply.
Okay. Mr. Jimoni prayed for some time to file a reply. The prayer is allowed, least after 3 weeks.
Lordship, sorry for the indulgence, Lordship. As far as the on the last occasion's direction, Lordship, at the bottom of the order, Lordship, then the council for NHIDCL prays for 1 week's time to receive instructions as to when the construction of National Highway 329A would start, Lordship. Pertaining to this, Lordship, instruction, Lordship, 329, Lordship, this National Highway has not been entrusted to the NHIDCL, Lordship. And there's a clear direction that to construct and to maintain, the direction was given to the MOD, the Union of India, and the state of Nagaland, Lordship. So if my submission may be recorded that no direction has been issued for construction of National Highway 329A as far as NHIDCL is concerned, Lordship. We are an agency under the MOD, Lordship. But unless there is a direction from MOD, Lordship, we have no authority to decide. So if my submission may be recorded that.
Okay, let you file the reply.
I'll file the reply, Lordship. But on this point, Lordship, the National Highway 329A, its description was changed. Initially, it was up to Tumla Junction. From the Assam to Tumla Junction. During the course of the first PIL, the extension was made from Tumla Junction to Mairamsi.
Yes.
Now, from the Diffu boundary till Tumla Junction, it is with the NHIDC.
Yes.
So it's a question
Okay,
of
let you file a reply first. After that, your submission will be considered.
Lordship, I have also stated categorically about the role of NHIDCL, Lordship. Maintenance has been, Lordship, entrusted to us, and we have already handed over to the state, Lordship.
Okay. First of all, let him file an objection.
Lordship.
Reply.
Lordship.
After that.
Much obliged.
For admission, item number 43.
May I please, Lordship? I 112 of 2023, Lordship, by an order dated 23/2024, I have been given time to file additional affidavit, Your Lordship. Additional affidavit I'll be filing in the course of the day, Your Lordship. So I pray that the matter will be listed next witness day, Your Lordship. That is on 1st of May.
Okay. E-Learning Council, Mr. T.B. Jameel, submits that pursuant to the order dated 20/03/2024. He will be filing the affidavit during the course of the day. I have also heard MS. You are appearing for? MS? Appearing for the state respondents. This is the matter on 1st of May,
My Lord,
2024.
obliged, Lordship.
For admission, Item number 44.
May I please, Your Lordship?
Yes.
Your Lordship, in this case, I am for the appellant. Your Lordship, I have some personal difficulties today, Your Lordship. So I pray that the matter will be listed on 8th of May, Your Lordship, for admission hearing. Your
Do you have any objection?
No.
Lordship, I'm appearing for the private respondents, three private respondents. And all of us are due for retirement with effect from 31st May 2024. So my anxiety is if more delay is caused and the matter is pending, then there may be some complications in our pension papers, Lordship. So
When they are retiring?
31st May 2024, next month.
Next month.
So let it be a firm date. If my learned friend is having difficulty, then
8th of May.
let it be, yes, that is okay.
Mr. T.B. Jamil, the learned counsel for appellant, submits that he has some personal difficulty today and on the ground that adjournment is grateful. The learned senior counsel, Mr. C.T. Jamil, appearing for the
Respondent
respondents,
number 1, 2, and 3.
respondents 1, 2, and 3.
My lord, I'm agreeing for respond number 4. Stay.
Has no objection. Heard, Mr.
For the state.
Appearing for the state also. The prayer, Mr. T.B. Jamil, is allowed. List on 8th of May
Lordship, for admission hearing.
for admission.
As a
Lordship.
fixed item. Lordship.
As a fixed item. Okay, all right.
Much.
Yes.
For admission. Item number 45.
Yes.
Please, my lord. Lordship, I have filed the interlocutory application praying for a condemnation of delay of 196 days.
Okay. Notice
In-
served or not?
Yes, notice has already been served.
Sir,
No private respondent, only the state respondent is here.
state respondent has no objection.
No objection regarding condemnation of delay.
Okay. How many days delay?
196 days, 196 days, which is including the holidays and the winter vacation.
Heard, Mr.
Send the young lordship.
Appearing for the applicant. Heard, Mr. So-and-so appearing for the state respondents. This is an application under section 5 of the Limitation Act, praying for condemnation of 196 days in preferring the connected appeal. The learned counsel for the state respondent has submitted that the state has no objection if the delay is condoned. Accordingly, the delay is thus condoned. The connected rate appeal shall be registered and listed for, oh, it is already listed. Shall be listed for admission
2 weeks, lordship.
after 2 weeks.
May I please, Your Lordship?
Yes.
Lordship, here my senior Joshua Shiki is appearing for respondent number 5. Therefore, I pray that my senior name may be reflected in the
Okay.
cause list.
It is also directed that the registration list show the name of Mr.
Joshua Shiki,
As the counsel representing the
respondent number 5.
respondent number 5.
For orders, item number 46.
Yes.
May it please your lordship. Lordship, by office order dated 6/12/2023, we have been directed to take step upon respondent number 2, your lordship, through OC Women PS, your lordship. Regarding that, your lordship, we have already submitted the service report, your lordship.
Notice served.
Yeah, it has been returned as unserved, your lordship.
No answer. Then what you will do now?
It may be deemed served, your lordship,
Lordship,
because this is the
Yes.
second.
Yes.
this is the second attempt that the state respondents are making through the women PS officer in charge. Now, lordship, this has been pending since 2022 because the steps have been unable to be effected to that, lordship. Now, lordship, in view of the notification issued on 20 March 2024, the implementation of the respondent number 2 is no longer mandatory, lordship. If I may be allowed to place the
Yes.
notification.
Play the judgment. Notification.
Rule 1A of chapter 11 of the Gauhati High Court rules have been amended by this
Yes.
notification, Lordship. So the appeal can proceed, Lordship, without the respondent number 2.
Yeah.
In view of this latest notification.
Okay, all right.
So if Lordship, respondent number 2 may be struck off from the area of respondents, so that the
We will appoint one legal aid counsel. Do you have this system, legal aid counsel?
yes, Lordship,
If somebody will represent her,
Lordship.
heard the learned counsel MS,
Yes, Mary,
yes, may pay for the appellant.
for the state, your lordship.
You are for the appellant. Heard Mr.
Cynthia.
APD for the appellant, heard MS so and so, APD for the respondent number 1. The notice issued to the respondent number 2 returned unserved. The learned counsel for the appellant has relied upon a notification issued by this court dated 28th March 2024 and submitted that it is not obligatory to serve notice upon the victim in such a case. Yeah, we have considered the submissions made by the learned counsels of both sides. Service of notice upon the respondent number 2 is deemed to be served, deemed to be complete. The office is directed to appoint one legal aid counsel to represent the respondent number 2 in this case. Lower court record was called for, but not. Lower court record is available. The LCR is available. List is made up for hearing. It will go for hearing. When do you want it?
The 2 weeks, Lordship.
After 3 weeks.
Not of that.
For orders, item number 50.
I spring for condemnation of 40 days delay in filing the connected.
Okay.
We have served the notice upon the respondent number 4 and 5. But however, they have not entered the appearance.
Today I'll be entering appearance on behalf of respondent number 4. I have instruction to appear.
Yes. You are appearing for respondent number 4.
Yes.
What is your submission? No objection. And who is for 1, 2, and 3?
I'm for 1, 2, and 3.
Or you are for 1, 2, and 3.
The respondent number 4 and 5, they are also official response. But however, we're initiating the modified action. So in view of that, we will get us an official in personal capacity.
You are for 1, 2, and 3.
And today I'm appearing for respondent
4 also.
My lord, and for respondent number 6 to 9.
Respondent number 6 to 9. Do you have objection?
Yes, my lord, I have instruction for objection, my lord, file objection.
Okay. At the learned counsel, Mr. Appearing for the applicant. Heard MS. Appearing for the respondents 1, 2, 3, 4. Heard Mr.
My name is that only, my lord.
Appearing for the respondents 6, 7, 8, and 9. The learned counsel submits that he has instructions to file an objection in this matter. His prayer is allowed. List again on when you will file objection.
After 3 weeks, my lord.
List after 3 weeks.
For orders, item numbers 51 and 52.
Yeah, please, your lordships.
Yes.
Your lordships, service notice upon respondent one was issued on 21/2/2024.
Just a minute.
23/2024, service upon respondent number one is still awaited.
Still awaited. He is the main respondent here. Principal respondent. So he should be heard. Wait for him. Yes. The service report has not yet come. Service report has come or not?
No, lordship.
Not yet
It's
come.
still awaited.
Then we will wait for some time.
No, lordship.
Heard MS,
Pim Hombeni is
preparing for the applicant. Heard Mr.
ET home for the respond number 2 to 5.
2 to 5. Await for the service report in respect to respondent number 1. He is from Okha.
Yes, lordship.
List after 3 weeks.
For hearing, item numbers 53 and 54.
May I please, your lordship?
Yes.
My lord, I beg to mention, my lord, here in item number 54, I'm yet to file affidavit. So can you allow me 3 weeks time, madam?
Who is for the appellant? Yes, you want to say something?
Your lordship, I don't have any objection.
Okay. In item number 54.
State system. Yet to
Mr.
file.
Also representing the state respondents submits that he is yet to file the affidavit and wait for some time. MS, what is your name?
Javitsu.
Appearing for the appellant submits that he has no objection. Accordingly, the prayer of Mr. So-and-so is allowed. When do you want it?
After 3 weeks.
List after 3 weeks. Allow me item number 53.
54. Yes. Yes.
Yes.
Much obliged.
For hearing, item number 68.
Yes.
She was appointed on a contract basis, your lordship, as a graduate teacher in 1998.
She was appointed as a teacher.
Page 72.
72.
Yes, the type copy is at page 72. Page 71 is the original, and the type copy is at page 72. Srimati B. Caroline Inchen BA is hereby appointed as ad hoc as a graduate teacher at GMS Teacher Colony under the establishment of the Deputy Inspector of School number 2 in the scale of pay of such and such plus special compensatory remote locality allowances at the present of such and such with all other allowances at the rate of from time to time with effect from the date of joining with effect from 2/6/98 to such and such by B in Mount La PT voluntary. So your lordship, the petitioner, she was appointed on a contract basis.
Ad hoc basis.
Yes, and during this point of time, your lordship, the government, we have an office memorandum that is only dated 18/2/2004.
Page number?
Page number 118, your lordship.
Yes,
your lordship. Your lordship, this is the memorandum dated 18 February 2004. As your lordship got it, page number
Yes.
118.
Ah.
So this is for regulation of contract ad hoc appointments. The government of Nagaland constituted a committee via notification such and such to examine the issues relating to the large number of ad hoc contract employees appointed in the past in various state government offices and recommend a workable solution in this regard. On the basis of the recommendation of this committee, a set of measures to be taken to deal with the existing situation and to prevent recurrence of such appointment in future were placed before the cabinet, which were considered and approved by the cabinet on 16 January 2004. In pursuit of this decision, the governor of Nagaland is pleased to order as follows. All fresh cases of ad hoc contract appointments will be taken up in accordance with the PNR Department Memorandum such and such 26 February 2001, and no such appointment will be made without following the revised procedure laid down in the aforesaid memorandum. 2. All the appointed authorities will take advance action to fill up the anticipated vacancies by following the prescribed procedure and avoid a situation where the extraordinary measure of ad hoc contract appointment has to be resorted to. 3. In respect of the existing ad hoc contract employees, the following actions will be initiated. So the petitioner comes at page 119, category number B, your lordship. Employees having 5 to 10 years of service. Page 119. An employee in this category may be considered for regularization, provided that in addition to the above mentioned three criteria, namely, there is a sanction post. The employee fulfills all the eligibility criteria for the post, including the requisite educational qualification. So, your lordship, this office memorandum 2004 provides for regularization of the ad hoc and contract employees, provided they have the requisite qualification, your lordship. So, a suitability test has to be conducted. So, your lordship, page page 76, your lordship. This is the paper publication dated 27/6/2005. Page 76. Calling all the persons who come within the purview of the OM 2004 to have a suitability test, your lordship. And the petitioner was told to have a suitability test on 13/7/2005. The petitioner was to be appeared for suitability test on 13/7/2005, lordship. And on the date of the suitability test, the petitioner, the contention of the state is that the petitioner never attended the suitability test. She didn't appear. So, the contention of the state government is that that is at page 171 in our affidavit, lordship.
171.
Yes. 17, this is our additional affidavit in opposition, your lordship.
Yeah.
Para 3, your lordship. That with regard to the statement in para 3 of the affidavit in reply filed by the petitioner to the affidavit in opposition filed by the state respondent, the following fully reiterates that there are no reports to show that the petitioner appeared before the screening board. This fact can be ascertained for the minutes of the suitability test enclosed with the affidavit in opposition filed by the state respondents. The state minutes records the names of persons who appeared the suitability test and placed them in various categories as per the test conducted. As such, earlier, the name of the petitioner cannot be found in any of the category listed. Even otherwise, the petitioner aptly admits that she could not submit the documents as required. As such, the chronological list of events narrated by the petitioner to show her presence and the affidavit purportedly sworn by some person, which is sought to be produced, are matters within the knowledge of the petitioner and is of no consequence. So, your lordship, we are denying that the petitioner did appear for the test. Then, your lordship, in our affidavit in opposition, that is at page 115.
115.
Yes. Lordship 114, this is para 12.
This is the affidavit of yours.
This is the affidavit filed by the state. Yes.
Para 114 para.
Para 12.
Hmm.
The second last line, Lordship, I may be allowed to read. The petitioner has a Lordship. Sorry. The last line. The petitioner, having been eligible for regularization, was directed to appear before the eligibility test. However, report will show that she failed to appear for the said test. The petitioner cannot therefore claim regularization of her service on this score alone. Para 13. That the statement made in para 12 of the repetition are misconceived and respectfully denied by the deponent. Eligible candidates who appeared in the eligibility test as directed were regularized in service. The minutes of the eligibility test conducted will show that there were no records of the presence of the petitioner in the said test. Even otherwise, it was the failure on the part of the petitioner for sleeping over her own case for regularization. As such, there are no legitimate grounds for alleging arbitrariness and or discrimination on the part of the answering deponent before the petitioner. 14. That the service of the petitioner cannot also be regularized for the fact that the law is clear in terms of the principle governing irregular appointment as laid down by the Honorable Supreme Court in the state of Karnataka and others versus Umar TV3, reported in 2006 for SSC 1, and the state of Karnataka and other versus M. Kasari, reported in such and such. The Honorable Supreme Court in the foreclosure cases has held, has held that the land of service cannot be the ground for regularization of irregular appointment. In the light of the above, the service of the petitioner cannot be regularized. 15. That mention may be made that in our own state, an organization under the banner of account, Action Against Corruption and Unabated Taxation, had approached the Honorable Court by filing WPC number 145 of 17. In the same petition, the petitioner had challenged the state government proposal of regularizing the service of employees who had completed 3 years of continuous service as per the memorandum dated 11/8/16, an office memorandum dated 4/8/2008, on the ground that because Lordship, while we have mentioned OM dated 11/8/2016 and OM dated 4/8/2008, is that the OM 2004 was already superseded, Your Lordship, on the ground that the same was in violation of the law laid down by the apex court in the case of state of Karnataka versus Umar Devi. In the light of the above, the Honorable High Court by its order dated 3/8/18 directed the state respondent not to regularize irregular appointment. Against the same, the state government filed writ appeal number 16 of 2008. The honor, Lordship, excuse me once.
So they have challenged the initial appointment also.
Your Lordship, in account, in account case, a group of public interested spirited person, they challenged the office memorandum of the government regularizing ad hoc and contract employees. So this honorable court has declared the OM to be unconstitutional. Being aggrieved by the judgment of the single judge, the state, we have filed an appeal before the division bench. So the division bench has upheld the judgment of the single judge. So now there is no more any order or memorandum to regularize the irregular or illegal appointment, Your Lordship. So this is the situation at the time, Your Lordship. Then the admission of the petitioner that she did not appear for the suitability test, I'll show you, Your Lordship, in page 178. That is his affidavit to our additional affidavit in reply. 178, Your Lordship. It's, Your Lordship, it's 176. This is an affidavit in reply by the petitioner. Then para 3. 177 para 3. But Lordship, I'll read from 178, page 178.
Yes.
Lordship, what we are saying is that the state we are saying is that the petitioner never appeared for the test. Because we do not have the record. Even the petitioner also, he admitted that he was late for the test, Your Lordship. One, three, Lordship, I'll read from the sixth line from the top.
Yes, on the
On
day.
the, yes, on the day the test was scheduled, that is 13/7/2005, the petitioner traveled from Bogotá to Kohima, starting out a down chauffeur by her younger brother in the family vehicle. The petitioner reached the Administrative Training Institute for brevity's sake, whereas the test was conducted around 9 a.m. to 10 a.m. When the petitioner reached the venue, the interview had already begun and the serial number had been called and passed over. On inquiry, the petitioner was informed that her name would be called after all the others in the list were called. Thus, the petitioner waited till the last moment of the interview. Finally, after all the candidates in the list for the day had been called and interviewed, the petitioner name was called. When her name was called for the interview, it was already dark in the evening. When the petitioner entered the interview room, the first thing the screening committee asked her was to produce her original documents of examination at the art, mark sheet, and certificate from examination through graduation. Unfortunately, the petitioner could produce only the photocopies of the admit card and mark sheet in respect of matriculation and pre-university, as she had lost the original and in respect of graduation. She could produce the original admit card and mark sheet in the public certificate, as she had no longer obtained the certificate from the petitioner therefore explained her circumstance to the screening committee and requested that she may be granted some time to apply for authentic copies of the admit card, mark sheet of matriculation from the Nagaland Board of School Education admit card, and mark sheet of pre-university from Northeastern University, certificate of graduation from the Nagaland University, and to submit the same to the board subsequently. The board allowed her request with the condition that she should obtain the document from the same institution at the earliest and produce them at the directorate immediately thereafter. With that said, the normal interview continued and ended, and as stated in paragraph 5 of the petition, the eligibility test consisted only of an oral interview. It is also pertinent to state herein that on 13/7/2005, when the petitioner appeared to interview, the person who appeared to interview just before the petitioner appeared, namely she, who was the last person in the list, clearly recalls that the petitioner entered into the interview room immediately. Lordship, just a minute. No. So, Your Lordship, that shows that on the day of the interview, the petitioner was late for the interview. And it is her admission that even she does not have the original document in her possession. Whereas the OM says that there will be a suitability test where all the person has to produce the original documents, Your Lordship. So the petitioner, since the contention of the state is that the petitioner never appeared for the interview. She alleged that she claimed that she appeared for the interview, Your Lordship. So she was never regularized, whereas the other person who had appeared for the suitability test were regularized. So the regularization was done in the year 2009. After a lapse of 15 years, the petitioner filed writ petition in 2020, claiming for regularization on the basis of the OM 2004, which is no more in existence, Your Lordship. Your Lordship, I'll show you the prayer.
Why it took so many years to file the writ petition?
That's the petitioner.
Lordship, I have made explanation. In 2005, this interview was held. Then after that, 2005, interview was held, the petitioner was allowed to submit her originals. After that, immediately after the interview, the petitioner applied for those, the duplicate copies from the university and I have enclosed those things also. After she obtained it, she submitted it before the directorate. Now, what happened was 2005, the matter was not taken up. They said over the matter in 2007 again, the board sat together in 2007. We had no knowledge how things, what was going on. It appears from the report that in 2007, the selected this committee, they sat again in 2007. And then in 2009 only, one batch was regularized. One batch. Then again, another batch was regularized in 2009. It was not in one go. I was completing the term. I was expecting that my turn will also come subsequently. But then it never came. In the meantime, the petitioner fell sick. The petitioner health issues, so she was running for her treatment and all. And medical reports, I think she had a mild stroke in the meantime. Then in 2019, the then director also made a proposal to the government to regularize her service like the others. But nothing, the matter just remained like that. I'll take your lordship to the particular.
Lordship, let me first submit, your lordship.
Okay, your lordship, allow her, your lordship.
Okay.
I'll take.
Yes, your lordship, because the claim of the petitioner is that she appeared for the interview and she was allowed by the authority to produce her original document in the subsequent days, your lordship. If that is all, that is belied by the reports. I'll show you the meeting minutes, your lordship. Page 121. Yes, your lordship. This is a meeting minutes, your lordship. Your lordship, page 133, this will show. They have made a category specifically explanation. Page 133, para 2, the following candidates were informed during the time of the interview about the need of the submission of the complete documents in original and also the personal initiative to inform the controlling officer to rectify defective SCR and to submit complete 5 years of SCR, which is mandatory, but they have failed to do the needful till date. Hence, the case will be taken up as and when complete submission of documents are done. If at all, your lordship, we have allowed her to bring her documents, her name will be here. Her name is not here, your lordship. So now the question is, the stand of the government is that she never appeared for the interview, your lordship. So she was never considered for regularization. The prayer of the petitioner, that is at page 68. Prayer of the petition of the writ petition, your lordship. In the premises aforesaid,
68.
yes, your lordship. In the premises aforesaid, it is most respectfully prayed that your lordship will graciously be pleased to admit this petition, both for the record and issue a rule calling upon the respondent to show cause as to why every in the nature of mandamus and other or direction should not be issued, directing them to regularize the service of the petitioner with effect from the date of her initial appointment, that is 495, as has been done in the case of other similarly situated teacher who appeared the eligibility test held in July 2005, your lordship. Then the conclusions of the learned single judge, your lordship. Page 193, this is the judgment dated 28/6/2022.
193.
Yes, 193 is the judgment passed by the learned single judge. 28/6/2022. I'll show you the relevant paragraph, Your Lordship, page 195, para 8. Para 8, Lordship. The case of the state respondent is that although the name of the petitioner was included in the list published, there is no report available to show that she had appeared for the test in the given day. What is important to notice here is that the state respondent have not totally denied that the petitioner did not appear for the test on 13/7/2005, but what they maintain is that the report showing her appearance for the test is not available with them. The other contention of the state respondent is that in view of the circular dated 6/4/18, which was issued pursuant to the decision rendered by this court in WPC 145/2017, the regularization of the petitioner cannot be taken up. 9. A perusal of the judgment and order dated 3/8/18 goes to show that this court had directed the state respondents not to regularize the service on any person in terms of the OM dated 11/8/2016 and the OM dated 4/8/2008. It may be seen that the memorandum dated 18/2/2004, which is relevant to the present case, has not been referred to in the same judgment. So, Your Lordship, the learned judge has come to a perversity. He is saying that in the division bench judgment, the order OM dated 18/2/2004 was not mentioned. That is why this court can direct the state to regularize her service, Your Lordship, upon completion of 5 years of initial. Then I will skip some paragraph, Your Lordship. Therefore, in my considered view, in the absence of specific denial by the state respondent that the petitioner failed to appear for the test on the date specified, she will be entitled to be considered in terms of the memorandum dated 18/2/2004, and that the circular dated 6/4 cannot be the basis for depriving her from such consideration. Then, accordingly, the state respondent 198 was directed to regularize the service of the petitioner in terms of the memorandum dated 8/2/2004, Your Lordship, within a period of 3 months. So, Your Lordship, having discovered that there was a typographical error in the office memorandum, Your Lordship, because Your Lordship knows that everybody is bound to make mistake. A typographical error, even if we go through the court judgment also, a slight typographical error is there, Your Lordship. So when that one is brought to the notice of the court, it has to be corrected, Your Lordship. So since the OM 2004 is no more in existence, Your Lordship, when the learned single judge passed that judgment of 28/6/2022, the state may have filed a review, Your Lordship. We have filed a review. Our review is at page 33. Civil review petition number 3 of 2023, Your Lordship.
Page number
Page number 33.
33.
Yes. This is our review, Lordship. Because the state is left in a position to do an impossible act, Lordship, because the OM is no more in existence. It has been superseded by the OM number 2007, against superseded by the OM 2008. And the OM 2008 was declared to be unconstitutional by this honorable division bench of this honorable court, Your Lordship. So we pray for review of the judgment dated 28/6/2022 by filing this review petition. But the learned single judge, he has dismissed our review petition, Your Lordship. At page 218, this is the other part by page 218 is a review order, Your Lordship, dated 31/10/2003. The operative part, Your Lordship, 221, your lordship. Para 5, your lordship.
2-1.
221. Para 5. Has your lordship got it?
This is, which memorandum is now, now in existence?
Now we do not have any memorandum, your lordship.
What about the 2008 memorandum?
That has been declared to be unconstitutional by the division bench of this honorable court. So what I'm saying is that the OM 2004 was superseded by OM 2007. Thereafter, the OM 2007 was superseded by the OM 2008. And the division bench of this honorable court has declared the OM 2008 to be unconstitutional. Whereas in the superseded OM, instead of putting 18/2/2004, there was a typographical error that the superseded OM was mentioned as 18/8/2004, your lordship. But that was even brought to the notice of the division bench of this honorable court. I'll show you. But lordship, before I read this, I'll show you the go to the notice of the division bench 161. This is the division bench in 161. WA number 16 of 2018. Yes, lordship, I may be allowed to dated 7/2/2019. Para 3, I may be allowed to read. Mr. Sema Learned Senior Additional AG placed before the court the office memorandum dated 4/8/2008 of the state government in the Department of PNR for regularization of contract effort appointment against sanction posts, by which the state government partially modified its earlier OM dated 23/8/2007. So this 23/8/2007, lordship, the OM 2004 was superseded by the OM 2007, your lordship. And the OM 2008 was 7 was superseded by the OM 2008, your lordship. So all these things has been brought to the notice of the court that there was a supersession of the orders. Only a slight changes, your lordship, partial modification only. Otherwise, the suitability test, all those things are there in all the OMs. Then, your lordship, I maybe take you to the decision arrived by the judge in the review, page 221, para 5. Maybe allowed to read. Against the above direction, the applicants have filed the instant review petition, and the main ground taken for review is that the office memorandum dated 18/2/04 was superseded by OM dated 23/8/07, which was in turn superseded by office memorandum dated 4/8/2008. Since the OM dated 4808 was declared to be unconstitutional by the division bench of this court by an order dated 7/2/19 in WA 16 of 2018, by upholding the judgment of the learned single judge dated 3/8/18, passing WPC such as such, it has now become impossible for the applicants to consider the case of review petition under the office memorandum dated 18/2/04 as directed by this court. The applicant have also taken the stand that the superseded memorandum dated 18/2 appearing in both the 18/8/04 appearing in both the office memorandum 23/8/07 and 4/8 should be read as 18/2/04 as it was a typographical mistake, your lordship. In the superseded, your lordship, instead of mentioning 18/2/2004, due to mistake, we have mentioned 18/8/2004, your lordship. Ms. Bishop-Grant learned additional supporting the statement made in the review petition submits that in view of the direction made by coordinate bench of this court in WPC such and such, directing the respondent authority not to regularize any person in terms of the office memorandum such and such, and for 18, there is no scope for considering regularization of the repetitioner, and therefore the review petition may be allowed as brief for. She submitted that the instant review petition is also not circumscribed by the law of limitation, and therefore the review petition be considered on merit. In support of her submission, she relies upon the case of Chandra Sharma versus the Board of Secondary Education, such and such, which was decided by a coordinate bench of this court. Then, Your Lordship, page 223, para 8. I have heard that the submission made by the learned counsel for rival parties, and I have perused the materials available on the court. The sole ground taken by the applicant for review of the judgment and order dated 28/6/22 passed by the court is that the office memorandum 18204 had already been superseded by the office memorandum dated 23/8/2007 and 4/8/2008. A perusal of the office memorandum goes to show that the earlier office memorandum dated 18/8/2014. So, Your Lordship, even here also, only I discovered last night, Your Lordship, there was a typographical error, even in the judgment itself, Your Lordship. So we are bound to make mistake. I discovered this only last night, Your Lordship. 18/8/2004, it should be 2004, not as 18/8/2014, has been superseded. But then the applicant contends that the office memorandum dated 18/8/2004 indicated was due to clerical mistake, and the same should be read as 18/2/2004. It may be noticed that the so-called clerical mistake has occurred both in the office memorandum 23/87 and 24/88. The same ought to have been corrected by way of a corrigendum and not simply by way of clarification addressed to the government council in view of the fact that office memorandums are issued for circulating certain information to all concerned and not to a particular individual. Even otherwise, the fact remains that the regularization of similar situated person at the relevant time was on the basis of a test conducted on 13/7/2005. In the writ petition, this court was of the view that the state respondent did not totally deny the fact that the writ petition appeared for the test conducted on 3/7/5, and only stand taken was that they did not have the record showing her appearance for the test. The further finding of this court was that the name of the writ petitioner was also included in the list of eligible teachers published in the local newspaper dated 29/6/2005. It was also under circumstances this court found that a similarly situated teacher have all been considered for regularization. The writ petition should not be deprived of a similar benefit. Therefore, while directing the consideration of the writ petition for a specific observation was made that the order should not be treated as a precedent, since the case of the petitioner was found to be left out and the case of the while all other similarly situated were given the benefit of regularization. It may further be noticed that this court passed the judgment in order so to be reviewed on 28/6/22, whereas the instant review petition was filed on 2/6/23, after almost a year. From a perusal of the statement in the review petition, more particularly at paragraph 7, it may be seen that the learned additional advocate general via her communication dated 2/9/22 sought for certain clarification from the department concerned in response to the instruction given to her to file an appeal. Although the clarification sought for was given on 5/9/22, no step were taken to either file an appeal or a review petition since 15/9/22, and it was only on 2/6/2023 that the instant review was filed. The case of Kada Chandra Supra, relied upon by the learned additional AG, was considered by division bench of this court in Mori TV, such and such. The court observed that because of what has been discussed and pointed out above, while we agree with the observation made in the case of Sri Kada Chandra Sharma, that Article 124 of the Limitation Act would not apply to an application for review of an order passed under 226 of the Constitution of India. We clarified that the High Court would not ordinarily entertain an application for review if the same is made beyond the period of 30 days as prescribed by the Limitation Act, on the ground that the public policy is not to ordinarily entertain an application for review beyond the period of 30 days from the date of making of the order. It would, however, remain open to the High Court to entertain in a given case an application for review, even if an application is filed beyond the period of 30 days provided the High Court is satisfied that the application has sufficient reason for not being able to apply for review earlier. The above observing a finding of the division bench was also agreed by the full bench of the High Court in the case of such and such. Coming to the present case, no explanation has been made or is discernible as to why the review petition was filed on 2/6/2023 for reviewing the judgment which was passed almost a year back. Such being the position and upon being due consideration again in its entirety, I do not find any ground to allow the review as being prayed for. Accordingly, the same is dismissed. So your lordship knows that the Supreme Court categorically stated that in the case of a review, the questions of limitation does not arise in reviewing an order which was passed by the High Court under Article 226. So even the single judge judgment directing the state to regularize the petitioner was passed under Article 226, your lordship. And your lordship sees that there is a pattern error on the face of the record, your lordship. The OM is no more in existence, your lordship. So if the state is to comply with the court order, your lordship, it amounts to the state to do an impossible act or to do contrary to the law passed by the division bench of this honorable court as well as the Supreme Court, your lordship. Your lordship, I'll show you the clarification. Your lordship, page lordship 119, your lordship. By this letter, I saw the clarification from the PNR whether the OM 2018 to 2004, your lordship, was superseded and whether there was a typographical error. And by page 200, your lordship, this is the letter given by the clarification given by the PNR department. Subject clarification on the office memorandum dated 18 to 2004 in reference to WPC such and such. I am directed to refer to your letter number such and such on the subject above and to clarify herewith as given below. 1. The OM dated 18 to 2004 has been superseded by OM number such and such dated 23/8/2007, copy enclosed. The superseded memorandum dated 18/8/2004 may be read as 18 to 2004 as it was a typographical error, your lordship. Then lordship page 205. This is the OM dated 23 August 2007. Regularization of contract ad hoc against sanction post. In supersession of this department memorandum of even number dated 18 August 2004, instead of 18 February, we have put 18 August. So this is, the PNR has clarified, your lordship. This is a typographical error. It should be read as 18 February, your lordship, because there is no 18 August 2004 memorandum. Then again, 2007 OM was superseded by the OM 2008, page 207. Here also we have made a mistake, your lordship. In supersession of this department of even number dated 18 August 2004, it should be read as 18 February 2004, lordship. So the PNR in the letter has clarified that there was a typographical error and that OM should be read as 18/2/2004 and not as 18/8/2004, your lordship. So your lordship, by not allowing the review filed by the state, your lordship, the learned single judge, he has acted totally irrational, your lordship, arbitrary, and even perversity, your lordship. The learned single judge ought not to have to go into a technicality, your lordship, when there is an error apparent on the face of the record. So, Your Worship, my prayer is that the review petition should be allowed, and the read petition, Your Lordship. The judgment dated 28/6/2022 passed in WPC 61 of 2020 should be dismissed, Your Lordship. I have a citation, Your Lordship. 1994 SCC online Gauhati 3 that review limitation does not apply, Your Lordship, in the case of a review, Your Lordship.
Nineteen ninety?
1994 SCC online Gauhati 33 or 1995 1 GAU LR 116. Or the other one is AIR 1995 GAU 82. Limitation doesn't apply in my case, Your Lordship. In my page is at para
1995.
I have 1994, but it will be if Your Lordship is having 1995 1 GAU or
Same. Oh, so it is same as AIR 1990. Yes. yes.
Lordship, paragraph 2, in my case is paragraph 2. I'll read from the chapter 10 of the Gauhati High Court rules provide for application for review of the judgment, and rule 1 of that chapter provides that the provision of chapter 4 shall apply so far as may be to every application for review. The chapter does not provide for review of the judgment of an oral application under Article 226. So it appears that review of order of an application can be made only in exercise of inherent power. And if this power is to be exercised under the inherent power, there is no question of period of limitation. Because a court cannot lay down a period of limitation, because that is legislative power and not judicial function. That the court can review its order in exercise of inherent power also is laid down in 1976 3 SCC. So this is a Supreme Court judgment they have referred. Instead of Gujaram versus Harda Begum, where the Supreme Court pointed out as follows. This patent error, which was perhaps due to inadvertence, could and should have been summato corrected by the High Court in the exercise of its inherent jurisdiction, even after the expiry of the ordinary period of limitation, if any prescribed for a review application. So it appears that what the court can correct in the exercise of its power to review is only patent error in the judgment. Number 3, in 1988, 1 ACC 363, the judgment of Venkata Chandya Judge J, as it then was mentioned, has been made to Article 137 of the Constitution. The aspect of the limitation was not considered in the judgment. Article 137 of the Limitation Act also shall not apply in the present case, in as much as the writ proceedings are neither a suit nor a petition or an application to which the Limitation Act applies. A petition presented before the High Court under Article 226 of the Constitution of India cannot be regarded as an application under CPC. It is entirely a different matter, but the High Court may consider the provision of CPC, which are based on equity, justice, and good conscience. In an application under Article 226 of the Constitution of India, the provisions regarding the addition of party substitution, etc., are not governed by the provisions of the Limitation Act, but the court may adopt those principles for its guidance. But the limitation provided in the Limitation Act shall not apply to the proceeding under Article 226 of the Constitution. This being the position, the question of limitation in reviewing the order passed by the High Court in exercise of the power under Article 226 of the Constitution shall not apply. So, Lordship, here the Supreme Court has categorically stated that The question of Limitation Act shall not apply in the case of reviewing an order passed by the High Court, Your Lordship. And if Your Lordship see there is a patent error, Your Lordship, then Lordship 2005 for ACC 741. Lordship, I read from page 765. As a Lordship got it, 765. Para 19.
Yes.
That's a mistake on the part of the court.
No, which para?
Para 90.
Para 90.
Page 765.
Oh.
90. That's a mistake on the part of the court, which would include a mistake in the nature of the undertaking, may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason. Therefore, what would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reason in Order 47 Rule 1 of the court are wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine, actus curia neminem gravibit. Then, para 92. Yet again in Lily Thomas, this court has laid down the law in the following terms. The dictionary meaning of the word review is the act of looking over something again with a view to correction or improvement. It cannot be denied that the review is a creation of a statute. The court in such and such held that the power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that justice is a virtue which transcend all barriers, and the rules of procedure or technicalities of law cannot stand in the way of administration of justice. So this is very much, Your Lordship, relevant to my case. I may be allowed to reread. It cannot be denied that justice is a virtue which transcends all barriers, and the rules of procedures or technicalities of law cannot stand in the way of administration of justice. Law has to bend before justice. If the court finds that the error pointed out in the review petition was under a mistake and the earlier judgment would not have been passed, but for erroneous assumption, which in fact did not exist, and its perpetration shall result in a miscarriage of justice, nothing would preclude the court from rectifying the error. 93. It is also not correct to contend that the court, while exercising its review jurisdiction in any situation whatsoever, cannot take into consideration a subsequent event. Then para 94. The Darbar vs. Narasimha Rao Krishnaji Kulkarni, the court noticed the impact of subsequent happening may now be spelled out. First, bearing on the right of action, second, on the nature of the relief, and third, on its importance to create or destroy substantive rights, where the nature or the relief as originally sought. So, Your Lordship, when the reliefs originally sought by the petitioner in 2020, the OM is no more in existence, Your Lordship, was not there, Your Lordship. So, where the nature of the relief as originally sought has become obsolete or unserviceable, or a new form of relief will be more efficacious on account of development subsequent to the suit, or even during the appellant stage, it is but fair that the relief is molded, varied, and reshaped in the light of updated facts, Your Lordship. Then, Lordship may come to page 769, para 106, 769. 106. Yet again, in Ramchandra Singh versus Savitri Devi, this court observed at paragraph such and such, in such an event also, the court may have to find out a remedy which should be just and equitable. The High Court furthermore failed to notice the principle actus curia neminem gravibet. In Rajesh D. Dabra versus Narasimha Rao Krishanji Kulkarni, this court noticed that the court can take notice of the subsequent events and can mold the relief accordingly. But there is a rider to this well-established principle. This can be done only in exceptional circumstances, some of which have been highlighted above. This equitable principle cannot, however, stand in the way of the court educating the rights already vested by a statute. This well-settled position need not detain us when the second point urged by the appellant is focused. There can be no quarrel with the proposition as noted by the High Court that a party cannot be made to suffer on account of an act of the court. There is a well-recognized maxim of equity, namely actus curia neminem gravitat, which means an act of the court shall prejudice no man. This maxim is founded upon justice and good sense, which serve as safe and certain guide for the administration of law. The other maxim is lex non cogic and impossibilia. The law does not compel a man to do that what he cannot possibly perform. So, your lordship, unless the learned single judge, your lordship, judgment is a question set aside and the review is allowed, it will amount to the state to do an impossible act, lordship. So, lordship, my prayer before this court is that there is an error apparent on the face of the report. Despite of that being brought to the notice of the honorable single judge, he dismissed the review petition only on the ground of technicality of delay, your lordship, that there was no explanation. Whereas I have pointed out to your lordship that the Supreme Court categorically stated that in the case of reviewing an order passed by the High Court under 226, the Limitation Act does not apply. So, lordship, my prayer is that the appeal may be allowed, lordship. That's humble submission.
Yes. May it please your lordships. I will take your lordship to the, before I come to the question of law, I'll take your lordship to the so-called impugned or judgment passed, order passed in the review. The review was not dismissed only on the ground of delay, your lord. Merits were considered. Yes. Page 218, your lordship. 218. Now, paragraph, I'll take your lordship to the paragraph. Paragraph 5, starting from paragraph. Yes. Page 221. 221? Yes, page 221, your lordship. Against the above direction, the applicants have filed the instant review petition and the main grounds taken for review is that the office memorandum dated 18/2/2004 was superseded by office memorandum dated 23/8/2007. You were reading the para? Para 5, para 5. Para 5, yes. If I may read again. Against the above direction, the applicants have filed the instant review petition and the main ground taken for review is that the office memorandum dated 18/2/2004 was superseded by office memorandum dated 23/8/2007, which was in turn superseded by office memorandum dated 4/8/2008. Since the office memorandum dated 4/8/2008 was declared to be unconstitutional by the division bench of this court by an order dated 7/2/2019 in WA 16K of 2018 by upholding the judgment and order of the learned single judge dated 3/8/2018 passed in WBC number 145K of 2017. It has now become impossible for the applicants to consider the case of the writ petitioner under the office memorandum dated 18/2/2004 as directed by this court. The applicant have also taken the stand that the superseded office memorandum dated 18/8/2004 appearing in both office memorandums dated 23/8/2007 and 4/8/2008 should be read as 18/2/2004 as it was a typographical mistake. 6. MS V. Shukri, learned additional advocate general, supporting the statement made in the review petition, submits that in view of the direction made by a coordinate bench of this court in WBC number 145 of 2017, directing the respondent authorities not to regularize any person in terms of the office memorandum dated 11/8/2016 and 4/8/2008, which was again upheld by the division bench in WA 16K of 2018. There is no scope for considering regularization of the writ petitioner, and therefore the review petition may be allowed as prayed for. She submits that the instant review petition is also not circumscribed by the law of limitation, and therefore the review petition be considered on merit. In support of her submission, she relies upon the case of Kanak Chandra Sharma versus the Board of Secondary Education Assam, so and so, 1995 1 GLR 116, which she has submitted presently, Your Lordship. 7. Mr. Tombok Pomoner, learned counsel for the respondent, on the other hand, submits that this court, in directing the respondent authorities to consider regularization of the service of the writ petitioner, did not simply rely upon the office memorandum dated 18/2/2004, but came to a finding that the state respondents did not totally deny that the writ petitioner appeared for the test on 13/7/2005, and it was only that the records showing her appearance for the test was not available with them. Therefore, this court found the writ petitioner entitled to be considered, since her case was left out at the relevant time. This court, while directing such consideration, had also made an observation to the effect that the order shall not be the precedent in future, as the writ petitioner was found to be left out from being considered for regularization in terms of the situation prevailing at the relevant time. He therefore submits that there is no merit in the review petition, and the same should be rejected. As regards the maintainability of the review petition on grounds of delay, the learned counsel submits that even if the Limitation Act does not apply in the present review proceeding, but the applicants ought to have given some explanation for the belated filing the review petition. As the same has not been done, the review petition is liable to be dismissed on this ground as well. 8. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. The sole ground taken by the applicants for review of the judgment and order dated 28/6/2022 passed by this court is that the office memorandum dated 18/2/2004 had already been superseded by the office memorandum dated 23/8/2007 and 4/8/2008. A perusal of the two office memorandums goes to show that the earlier office memorandum dated 18/8/2014 has been superseded. But then the applicants contend that the office memorandum dated 18/8/2004 indicated was due to clerical mistake, and the same should be read as 18/2/2004. It may be noticed that the so-called clerical mistake has occurred both in the office memorandums dated 23/8/2007 and 4/8/2008. The same ought to have been corrected by way of a corrigendum and not simply by way of clarifications addressed to the Government Council in view of the fact that office memorandums are issued by circulating certain information to all concerned and not to a particular individual. Even otherwise, the fact remains that the regularization of, this is very important, Your Lordship. Even otherwise, the fact remains that the regularization of similarly situated persons at the relevant time was on the basis of a test conducted on 13/7/2005 in the writ petition. This court was of the view that the state respondents did not totally deny the fact that the writ petitioner appeared for the test conducted on 13/7/2005. And only stand taken was that they did not have the records showing her appearance for the test. The further finding of this court was that the name of the writ petitioner was also included in the list of eligible teachers published in the local newspapers dated 29/6/2005. It was under such circumstances that this court found that as similarly situated teachers have all been considered for regularization, the writ petitioner should not be deprived of a similar benefit. Therefore, while directing the consideration of the writ petitioner for regularization, a specific observation was made that the order should not be treated as a precedent, since the case of the writ petitioner was found to be left out case at the relevant time, while all other similarly situated teachers were given the benefits of regularization. So your lordship, merit, it has gone into the merit. The court has held that at the relevant point of time when the interview was held, conducted, it is the case of the petitioner that she appeared at this. The state is also not saying that she did not appear. They are only saying that there is no record showing her appearance. But at that relevant point of time, all others who were similarly situated were regularized. So in this case, the court took the view that whether the 2004 notification, the memorandum was in existence or not is of no consequence. At that relevant point of time, she was eligible, she appeared. The only stand of the state respondent is that her records are not found. Because of that, this court has directed that she should be treated similarly with the other eligible candidates who appeared at that point of time. So that is one. And then the court also went into the question of delay in the case of filing the instant review. So the entire merit was was considered, and the court has dismissed the review petition. Now your lordships are well aware of the law on with regard to review. Your lordships, but I would like to take your lordships to the order 47 with regard to review. Order 47 of the CPC, starting from rule 1.
Yes.
If I may read, your lordship, application for review of judgment. Number 1, any person considering himself aggrieved. Number A, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. This is very important, your lordship. They could have filed the appeal, but they decided not to prefer. They preferred the review petition. Number B, by a decree or order that they are not very important, but then the grounds. There are only 3 grounds, your lordship. It is C, by a decision on a reference from a court of small causes, then, and who, from the discovery of new and important matters or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at a time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of the judgment to the court which passed the decree or made the order. So, on the basis of discovery of so-called new evidence, they have decided to file the review. Now, they decided to forego the right to appeal in this case. Now, once the review has been considered and in its merit decided and rejected, whether appeal can be preferred against the review or not, your lordship. Rule 7. Rule 7 of the same order.
Yes.
Rule 7.
Order rejection.
Yes. Order of rejection not appealable. Objections to order granting application. 1. An order of the court rejecting the application shall not be appealable. Your lordship, in this regard, I'll just give a citation. This is one page. This is a Supreme Court decision. This is an order. This is 1994 to SCC 753. Lordship. It has been dealt with in very short shift manner. 1. This appeal is obviously incompetent. It is against an order of a division bench of the High Court rejecting the application for review of a judgment and decree passed by a learned single judge who seems to have retired in the meantime. It is not against a basic judgment. Order 47, Rule 7 of CPC bars an appeal against the order of the court rejecting the review. On this basis, we reject the appeal, no cost, Your Lordship. So that is, it's essentially an appeal against the rejection of the
Review petition.
So now, Your Lordship, with regard to all those issues that with regard to the facts of the case, Your Lordship, in order to satisfy this honorable court, I would like to take Your Lordship to the main facts of the case. How the petitioner aggrieved has approached this honorable court. Though it may not be of much necessity at this stage, but I would like to satisfy Your Lordship. My writ petition, Your Lordship, which is at page 53, starting from page 53. Page 53 is the now. I'll just take Your Lordship through my pleadings because trying to submit is, I may not completely do justice to it. So I'll take Your Lordship through the pleadings, Your Lordship. Page 63, 11 paragraphs.
63.
Yes. Page 64, Your Lordship. Page 64, I'm sorry. Paragraph 5. Since it has to do with the eligibility test. That the eligibility test was conducted in July 2005 in different batches, and the petitioner appeared the test on 13/7/2005 as directed in the department publication. The test consisted only of an oral interview. While appearing at the test, all the teachers were directed to submit original documents of examination admit cards, mark sheets, and certificates from matriculation through graduation. Unfortunately, in the case of the petitioner, she had lost the original admit card and mark sheets in respect of matriculation and pre-university, and was in possession only of photocopies of the same. And in respect of PA, she only possessed the original admit card and mark sheet, and had till then not obtained her graduation certificate from the university. She therefore requested permission from the authority to appear the test based on the documents available with her. And the authority granted her the permission to appear the test on the condition that she should submit the originals subsequently. After appearing the test, the petitioner applied for duplicate copies of the admit card and mark sheet of matriculation and pre-university from the Nagaland Board of School Education, NPSC, the Northeastern Hill University, Nihu, Shillong, and the said copies dated 29/8/2005, 8/8/2005, respectively, were issued to the petitioner. The petitioner also applied for the original copy of the graduation certificate from the Nagaland University, and the said copy dated 29/7/2005 was issued to the petitioner. Upon obtaining the said documents from the said institutions, the petitioner submitted the same to the department, and the department, having verified the genuineness of the documents, returned the originals to the petitioner. 6.
Actually, your case is based on Order 47, Rule 7.
Yes, Your Lordship.
That is your case.
Yes, Your Lordship. And it was dealt with even on the basis of merit also. These are
Other things are not.
single bench. So I will just submit for.
Yes.
Yes, Your Lordship, if Your Lordship is not inclined to go through all the facts, but the judgment is very clear. And there is single bench judgment. Now, I would just like to supplement one case here. When the court, this honorable court has power under Article 226, when the court's conscience is hit, the court has power to pass orders, even if there is delay also. This is the judgment. This is a 2003 1 GLD 526. Here, I'll just take your lordships, this case was a peculiar one. In 1985, the petitioner herein was appointed as knitting instructor on fixed lump sum payment against no vacancy. Vacancies arose in 1986. Selection board said, she along with 2 others were selected. What happened was, against the post which was meant for her, one of the ministers appointed his own candidate directly, and the petitioner was kept on lump sum. Then in 2001, the petitioner's appointment was cancelled. She approached this honorable court, the single bench, after more than now 10, 12 years. She approached this honorable court, the single bench, dismissed her case on the ground of delay and laches. That she had said over her right all these years, but then what did in this case, the division bench, led by the then Chief Justice, they held that no, these kind of cases, the court cannot countenance these kind of cases. She is entitled for regularization from the date, that is 1986. In 2003, this was passed. 1986, she is entitled to be regularized along with the other two who were selected at that point of time. This is the crux of the case. So I'll take your lordship to the page 6. No, sorry, paragraph 6 here. Paragraph 6. The dismissal of the appellant's writ petition on the ground of laches does not justify the power to be exercised by the court under Article 226 of the Constitution, in the facts and circumstances which has been brought on record. For the aforesaid reasons, we set aside the order dated 23/8/2002 of the learned single judge in WPC 175K 2002. We are aware of the fact that normally courts are not expected to direct appointments to the post, but to direct consideration of the case for appointment. But then there are always exceptions to the general rule. And in each and every case, the court is not bound to follow this rule, which is more of prudence than of law. In a given circumstance, when the court's conscience is shaken by a blatant and naked act of executive, which impugn upon the basic principles of rule of law, the court shall act and shall not remain silent spectator. In the facts and circumstances of the present case, we have to direct the state respondents to give regular appointment to the appellant petitioner from the date on which Srimati T. Shilomongla and Srimati Pangchong Mongla were given regular appointment to the post of knitting instructor. The appellant shall be directed for the differences of regular salary which he is entitled to, and the salary which has been paid to her from time to time from the date of her regular appointment. The appellant shall also be entitled to all the service benefits which under the relevant service rules the knitting instructor is entitled to. The writ appeal is allowed, no cost. So this is, the instant case is also an exceptional one. All those who were similarly situated, they were granted regularization in 2009 and 11. The petitioner was expecting that her case would also come, but it never came. Now the court, considering that the state is not denying she did not appear, they are only saying that reports are not found. But why the reports are not there? Because in 2005, this interview was conducted. 2007, after 2 years, these courts sat. One second. In 2007, by that time, during the interim period, what happened, we don't know. All these are there. So, taking into consideration all these things, this honorable court deemed it that it is an appropriate case where the petitioner also should be. Now she is almost nearing her retirement. 1998, she was appointed. 2024, she is still on ad hoc. While all those who were regularized,
She is still working.
she is still continuing as on ad hoc basis because hers is a substantive post against which she was appointed.
She is still working.
She is still working. She is still serving.
Okay.
This is the position, Your Lordship. With that, I raise my case.
Clarification, Lordship.
the stake, the intention of the stake is that she never appear for the test. But in the judgment, the court has recorded that we do not have the record. The contention of the stake is that she never appear for the test. I have shown you her reply. Petitioner also admitted that on the day of the test, she was late for the test, and when she reached, her roll number was already called over, Your Lordship. I've shown the admission on her part. And even Your Lordship, she also admitted that on the date of the test, she does not have the original certificate, Your Lordship. Then the other one, he raised that the appeal is not maintainable. Your Lordship, I have challenged the review, the order passed in the review, as well as the judgment passed in the repetition. So appeal is maintainable, Your Lordship. Had I challenged only the review, Your Lordship, then appeal would not be maintainable. But I'm challenging the original repetition judgment in the repetition, Your Lordship. So the appeal is maintainable. That's all, Your Lordship. Much obliged.
But you are challenging the order dated 28/06/2022.
I'll show you my prayer, Your Lordship. That's at page 32. 31, Your Lordship.
Page 21.
31, 31.
31.
The relief sought in this appeal in the premise aforesaid, it is most respectfully prayed that Your Lordship may graciously be pleased.
In the page?
31, 31, 31.
Just a minute. One.
Lordship,
Yes. 3-1 prayer.
Yes, yes. Relief sought in this appeal. It is most respectfully that Your Lordship may graciously be pleased to admit this appeal. Issue will call for the records of the case and on perusal of the records. And upon hearing the parties be pleased to A. Question set aside the judgment and order dated 28/6/22 passed in WPC 61 of 2020 and dismiss WPC number 61 of 2020. B.
Okay, all right.
Yes, all right, yes.
All right, judgment reserved. Yeah, right. No. That's okay.
Hello, ako mga to bye bye.
I know, but yes, I want this.